court officer please announce the case?
Merci, Monsieur le Président.
The court officer, thank you. Situation in the Republic of Kenya. In the case of the prosecutor versus William Samuel Ruto and Joshua Arapsang, ICC 0109-0111. We are in open session.
Thank you very much. Appearances.
Morning, Your Honours. Anton Semek for the prosecution. With me, Lucio Garcia, Lara Renton, and Yasmina Suljanovic.
Good morning, Mr. President, Your Honours. I am assisted by Mr. Ochlon Narantsetseg from the OPCV and Mr. James Mawira, my case manager. I'm Wilfred Nderitu.
Mr. President, Your Honours, good morning. The appearances for Mr. Ruto, who is in court, remain unchanged.
Microphone, please.
President, my apologies. Good morning, Mr. President, Your Honours. The team for Mr. Sang remains the same, only that Ms. Rong Choi is absent today.
Thank you very much. Mr. Khan?
Mr. President, Your Honours, we're most grateful for the opportunity to have reviewed the video, and at the outset I will express particular gratitude to the court officer and the technical staff of this court, because they allowed us to stay until 7 p.m. Watching the video in the court premises, and that was exceptionally kind of them, and I know it delayed them from their private lives as well as their other responsibilities. So thank you for that. Your Honour, the video made very interesting reading. I won't go into detail at the moment. We saw, for example, the witness keeping notes and hiding the notes in his pocket at the end. But Your Honour, I accept that after reviewing the video, the prosecution are quite right. He's an incredible witness. He gives an incoherent account.
Point now is on the withdrawal.
Yes.
Request.
Your Honour, I do not oppose the application of the prosecution to withdraw the witness. There is, of course, a larger question as to why it's taken 4 years to rely upon such a witness to this stage that's so obviously incredible before withdrawing him.
One second. I think there will be, if that is going to be part of your case, that will be an appropriate time for you to make submissions in that connection.
Indeed.
And let's not do that now. The prosecution had invited the defense to consider consulting with the witness. Do you intend to do that so that we will know from the bench what directions to give to the VWU?
Your Honour, I don't intend to waste time speaking to this witness. I would like to spend my time on interviewing witnesses that I believe will give reliable and truthful evidence. So, Your Honour, I'm not going to take the prosecution up on their kind offer. Your Honour, I do say for the record that we've seen a witness that's been relied upon disintegrate and being seen to be obviously incredible. And I do say there's a bigger question, not whether or not this witness should be withdrawn, but whether or not the prosecution, in the time that they will have, decide to withdraw this case. This is a very real issue. I've said before, it's not rhetoric, and I'd ask that they review the evidence, including the summons application, to make an informed and objective and professional view on that very central issue. Why are we here?
All right. We've had you on the record, and at the appropriate time, I believe, if there's a need for you to submit upon that, you will know what to do. But we're not doing that now. Mr. Steinberg.
Thank you, Your Honours. I trust you're not inviting me to respond.
No, we're not going to debate
about
the content of the video and its significance at this stage. If Mr. Khan wants to make a dedicated issue out of it, he should file an appropriate application in that regard at the right time. Or if that's going to be part of his case, he will weave it into the case. But we're not going to debate that now.
Your Honours, may we go into private session as I'm going to speak about the availability of witnesses?
We will then, before we do that, 1 second. That's another issue.
It is another issue. I have nothing further to say on the issue of Witness 25.
In light of Mr. Khan's submissions just now, the Chamber grants the prosecution some request to withdraw this witness from the witness list, and the registrar is directed to release the witness in the normal course. Thank you.
Thank you, Your Honours. We would like at least to inform the witness personally of our reasons, if that's in order. Your Honours, that brings us then to the issue of the way forward.
So you want us to go into private session?
Indeed,
right?
thank you, Your Honours.
We'll go into private session.
Nous sommes en audience publique, Monsieur le Président.
The court officer, we are in open session, Your Honor.
Counsel, can you react to a request to adjourn till late June or early July?
Your Honour, exceptionally, I will not object on this occasion to an adjournment until June or July, end of June or beginning of July, but with one important caveat. The prosecution do not have the luxury of choice. They do not have a right to delay. It is the defence pursuant to Article 67 that has a statutory right to an expeditious trial. And we, in our respectful submission, have been unbelievably cooperative in not raising a huge fuss regarding the trickle of witnesses that have been brought forward and the aborted sessions that have taken place due to no fault of us.
But Mr. Khan, I mean, that's not unusual in litigation. Often difficulties in litigation come up, and both prosecution and defense don't make a lot of fuss about them unless there's a real serious issue too.
Well, Your Honour, with respect, it's a little bit different because the bench, yourselves, as well as the defence, have previously said that reserved witnesses should be available on standby to fill sessions, to make sure that hearings are meaningful. Now, Your Honours, my submission was that there was one witness that was scheduled to come at later on this month, and I told my learned friend, Mr. Steinberg, as he indicated, that it didn't make sense, really, to reconvene, come from all over, particularly we're not in receipt of legal aid, to come from all over the world for one witness, in relation to whom, actually, we have hardly anything to ask. So, Your Honours, what I would ask is, we have the next session. It seems that there are 4 witnesses that are available to testify so far. 4 witnesses are clear-cut. The rest have indicated they're not willing to attend or subject to the summons application. The prosecution be ordered to get their ducks in a row so that those witnesses come to fill the next session. And then the case should be closed, subject, of course, to the summons decision. Your Honour, it's not fair, we say, to be expected to start preparing for witnesses and keep investigating for witnesses that have indicated to the prosecution they're not willing to attend, or the prosecution say they're no longer relying upon. Your Honour, we want this case to close before the summer break. It is causing, understandably, huge difficulties for the clients, for Mr. Ruto, for Mr. Sang. Their name has been tarnished long enough. We want this case to come to an end. Your Honour, there's no reason why the prosecution should be given an indulgence to have adjournments as if it's a matter of course. So what we're saying, on this occasion, we're being, once again, reasonable. We're saying, okay, have your adjournment until June, even the beginning of July. But at that point, you get your witnesses together, and you close your case once they've testified and been cross-examined, subject to the witnesses that are subject to the summons application. That ring fences our work. It's an efficient way of proceeding, and we say it's the appropriate way. Your Honour, in relation to one witness, and this is what I'll have to mention his pseudonym if I may. It's 32. Your Honour, the prosecution say that witness, we've discussed him before, and it's linked, in fact.
Well, let's stop there, Mr. Ken. We're not going to require the prosecution to close its case subject to the summons application, so I can tell you that up front. It doesn't work that way. If there are some witnesses that are still in the zone or issues of that nature that remain to be resolved, there are other ways of dealing with it other than saying close your case subject to possibility of calling some other witnesses. Let's not do it that way. Your response now, the remainder of it would be to require the prosecution to make sure that upon the next session that the witnesses are there to be taken. That's it, isn't it?
Your Honour, that is it. But also in relation to two witnesses that they mentioned very cryptically, domestic mechanisms or domestic proceedings. It's not right, we say, that a party to litigation, the prosecution, can talk in such cryptic ways to the bench when the defence have not been briefed at all about what the prosecution have in mind for those particular witnesses. So, Your Honour, whatever the state is, we simply say that the prosecution get their witnesses together, we have a meaningful session on the next event. We have, and we ask the bench to be alive to it, every interest in having this case determined on the merits as soon as possible, and we'd ask that everything be geared to concentrating the witnesses so that we don't have this as a very painful, more painful I should say, drawn out, expensive and inconvenient process, which is contrary of course to our rights under Article 67. Your Honour, it's our respectful submission that in relation to these 4 witnesses that have been that are available and willing to testify, we can finish with all 4 within 3 weeks. So if there's a session of 3 weeks, all 4 of those witnesses can be led in chief, cross-examined by the defence, and then all we're left with are the witnesses subject to the summons and any other witnesses the prosecution may wish to call that were on their witness list.
When you say 4 witnesses,
you're
of course discounting the ones the prosecution, we're not mentioning them, the ones the prosecution indicated that they are not likely to call because of the ex parte nature of the testimony. Those are not part of the 4 you have in mind.
Well, Your Honour, perhaps I can go into private session.
Yeah, let's go briefly into private session.
Nous sommes en audience.
The court officer, we are in open session, Mr. President.
Mr. President, the position of the team for Mr. Sang is the same. We support this application. We think there should be one final session for the 4 witnesses mentioned to be called, and then we will all wait for the subpoena issue to be resolved. In addition, we would like to receive a formal indication from the prosecution that the remaining 7 witnesses are formally withdrawn, because there are still 7 witnesses on the list who have indicated at some point or another that they're no longer willing or unable to testify. And at this moment, we still have no formal indication that they've been withdrawn. We think the time is ripe for that to be done.
Essentially, you're requesting a cleaned up list of witnesses.
Indeed, Mr. President.
Mr. Steinberg, are you in a position to speak to any of these?
Your Honours, I do have some difficulty with the last request, and that is that we have seen with certain witnesses who have indicated that they were not available, that they do change their minds. The last witness was one in case. I won't mention names or numbers.
Should we go back into private?
Yeah, perhaps.
All right, let's go into private session. So we're not speaking in cryptic tones.